I don't need a mic. Okay, good. There we go. Good morning again. Thank you all again for being here. Our next presenters are not strangers to peer group conferences. When I reached out to Mr. Vinti a few weeks ago, not only did he respond immediately, but he also asked his colleagues to join him and once again participate in a peer group conference. We're very fortunate to have good partners from Proskauer. Please welcome Baldo, Jeff Warshafsky, and Jennifer Yang.
Thanks, Bernard. And thank you all for attending this morning. So, as Bernard mentioned, my name is Baldo Vinti. I head the IP litigation group at Proskauer, and with my colleagues, Jen Yang and Jeff Warshafsky, who are also in the IP group. And a lot of what we do is really defense work in class action, consumer class action litigations. And what we've been seeing in recent years is an uptick in ESG type litigations. So I would say after health-related claims, ESG claims are probably the most prevalent of the claims that we see. And so we thought it would be a good topic to talk about. I know there's a lot of overlap between various sections today because that's just how prevalent these type of cases are. So we'll talk about litigating consumer class actions in the ESG space. We'll talk about topics such as the environmental green guides, carbon neutral claims, recycling claims, biodegradable claims. These are all environmental type claims that many companies are making, and because they are investing a lot in environmental claims. They're investing a lot in renewable energy. They're investing a lot in making sure that their products are environmentally friendly. And of course, whenever companies invest money in a particular area, there's always folks that try to exploit that. And so, hence we have class action. So we'll talk about recent cases. We'll talk a little bit about compliance with various regulations and case law. And so can't really start talking about environmental claims without talking about the green guides. And the green guides were issued by the FTC. I'm sure a lot of you are familiar with these green guides. If you're not, you should definitely take a look at them and know them well if you're in the space. The last time they were updated was 2012. And so obviously it's over a decade ago. There's been a lot of changes that have happened in the world, and especially with respect to environmental claims. Companies understand the importance of these claims. They're devoting more resources to these claims, and so now the FTC is looking to revisit those guides, and they're seeking comments. So there's a whole section on their website about providing comments. The green guides not only tell you what's proper and what's not proper, but they also tell you how to substantiate claims, and also they give various examples of what's acceptable, what might not be acceptable, and so on and so forth. So it's obviously a good idea to be in compliance with the green guides, because courts will look at them. Courts will look at them to see what are the specific examples that are given, what do they communicate to consumers, and they also look at the green guides for the proper substantiation for certain environmental claims. And in fact, in some courts, or some states, especially the state of California, where a lot of class actions do take place, if you're in compliance with the green guides, then that's a complete defense to a challenge. So you'll see today, you'll also see if you read the guidelines that there are a lot of examples, very specific examples. There's also a lot of gray area. And so even when a company is trying to do the right thing, looking at the green guides, looking at their substantiation, there's always class action lawyers that are trying to look for loopholes and trying to exploit those gray areas. So that's why it's really important that if you're making one of these claims, that you really vet the law, you really vet the green guides, and then it's important to talk to your lawyers, right? To make sure that not only you're in compliance, but that you have a story to tell and a defense to present when you're challenged. So That doesn't mean that you're going to be successful on every motion to dismiss, because obviously, as a company or defendant, you're going to be limited in what you can do on a motion to dismiss. You can't, for example, bring in new evidence, right? You have to live within the four corners of the complaint. That doesn't mean you're naked. So what we'd like to do is, especially for these environmental claims, we'd like to not only have the substantiation before they're made, but also what is our story? So what does that mean? That means perhaps retaining third-party experts, having not only internal testing, but having external testing ready to go. Because if a case is filed, you want to be able to present your best defense early on. And we believe in having frank and candid discussions with defense counsel, with plaintiff's counsel early on. And we show the evidence, because just because someone may win a motion to dismiss, it doesn't mean they're going to win at the end of the day, even after class certification. And so if someone's going to go down, the plaintiff's lawyer is going to go down this path of litigating a case only to lose, it's important for them to understand what their risks are early on. And so that's why we believe in sharing the information early on. And the only way you can do that is if you're prepared in advance. So with that, I will turn it over to my colleague, Jennifer.
All right, so we're going to start with general environmental benefit claims. So what are these? These are your claims like eco-friendly, good for the environment, broad environmental benefit claims. All right, so here's what the green guys have to say about general environmental benefit claims. So the short version is, avoid them. So this is basically the FTC's term for greenwashing, which we've all heard of. And the green guys basically say these claims communicate to consumers that the product or the service has no negative environmental impact at all, and even perhaps that it has far-reaching environmental benefits. Pretty much impossible to substantiate. So the FTC says just avoid these claims altogether. Having said that, there are ways to qualify what would otherwise be a general environmental benefit claim to be more specific about what it is that you're really claiming. So as with everything in advertising, it's context dependent. When you see a general environmental benefit claim, it's all about looking at the context and whether that communicates to consumers what it is that you're actually talking about. So this is an example from the green guys, eco-friendly. Eco-friendly by itself is a general environmental benefit claim. But if you qualify that claim to say eco-friendly made with recycled materials, that then tells consumers exactly what it is that you're claiming is the environmental benefit. Then you just have to make sure that you have the right substantiation for that recycled claim. All right, here we have another example from the green guides. So here an advertiser has packaging that weighs 15% less than it did previously, and is claiming that its packaging is now greener than our previous packaging. Probably literally true, right? It's literally accurate that it's greener by virtue of having less material, perhaps being easier to ship. The green guides say that that claim would be deceptive because consumers likely would interpret greener in that context to mean that other aspects of the packaging are also improved. For example, packaging, they might interpret it as meaning the packaging is now recyclable, whereas it wasn't before. So bottom line here is just make that disclosure that when you say greener here, what you're talking about here is the reduction in the weight of the packaging. As with all things advertising, look out for your implied claims. So here the green guides give an example of a bird's nest on a tree branch surrounded by a dense forest, that being a general environmental benefit claim potentially. But the point here is more generally just look out for implied claims. All right, moving on to some class actions. So these types of claims are a target for class actions. This was a class action filed against Aldi, alleging that Aldi was falsely advertising its salmon as being sustainable. So you can see the claim here, simple, sustainable seafood. So according to the plaintiff, the word sustainable here was communicating to consumers that the product was made from salmon sustainably sourced in accordance with high environmental and animal welfare standards. And plaintiff said, Aldi's salmon actually is not sustainably sourced because it comes from large industrial farms that use environmentally destructive and unsustainable practices. So Aldi filed a motion to dismiss with a few arguments. First, Aldi said this label isn't misleading in context. So if you look on the upper right there, you see the BAP certification. So BAP is a third-party organization that certifies that products are sourced in accordance with best aquaculture practices. And Aldi said their BAP qualifies the sustainable claim, and it basically means that sustainable here just means that the product has received that certification and has met those standards. The court said that wouldn't cut it for Aldi. It noted that the BAP certification was separate from the sustainable claim, and also said reasonable consumers might not know what BAP means and might not know that it has anything to do with sustainability, so that wasn't enough to weight the two. Second, Aldi did argue puffery and said sustainable here was non-actionable puffery. The court disagreed and said sustainable was attempting to connect the product to at least some sort of environmental benefit here. Baldo mentioned courts often look to the green guides, so the court here did point to the green guides on unqualified general environmental benefit claims and said that this is what Aldi was doing here with the word sustainable. All right, but like I said, it's always context dependent, and here we have a case that came out a different way involving a sustainable claim. So this was a case brought by Earth Island Institute against Coke under DC CPPA. And here, Earth Island was alleging that Coke was engaging in greenwashing because, according to the complaint, Coke is a major plastic polluter. It is not making significant efforts to operate a sustainable enterprise and is breaking its sustainability promises. The court disagreed and granted Coke's motion to dismiss. So the court grouped the statements that were being challenged into two buckets. So the first are these statements here, what the court called general aspirational statements and big corporate ethos. And then there was a second bucket that the court called more specific future statements. So things like part of our sustainability plan is to help do these things globally by 2030. We want to make 100% of our packaging recyclable globally by 2025, so on and so forth. So the court did find that Earth Institute failed to state a claim as to all of these statements for three reasons, really. So first, the court said the challenge statements were aspirational. So the first bucket that we looked at, those were general statements about future goals and vague corporate ethos that didn't contain any promises or measurable data points to determine their truth or falsity. And then as to the second bucket, the court said it couldn't assess whether Coke had met those goals since the target dates were far in the future, 2030, 2025. The court second noted that the CPPA's requirement that the challenge statements had to be tied to a product or service was not met here, because the statements appeared only in corporate communications, not on a physical product. And then finally, the court rejected the argument by plaintiff that the challenge statements created a general impression or a mosaic of representations that were misleading. The court basically said, CPPA here provides a cause of action for a misleading statement of material fact, and not just a general impression that's created by a bunch of statements together.
So we're going to turn to carbon offsets and carbon neutral claims. The green guides address carbon offsets and basically provide three requirements. First, marketers should account for offsets using competent and reliable scientific evidence. It's a high standard, and so we'll look at a few cases where that comes into play. Second, marketers should disclose when offsets won't occur for 2 years or longer. The idea being that if you're starting a project to offset carbon emissions, but say you're planting trees and those benefits won't be realized for a number of years, it could be misleading, according to the green guides, not to disclose the length of time. And then third, you shouldn't advertise a carbon offset if it's required by law. So the green guides don't actually address carbon neutral claims or carbon free, etc. That may be an area that the FTC addresses in the revised green guides that Baldo mentioned are forthcoming. It's definitely been an area where a lot of commenters have urged the FTC to provide greater clarity, and I think the class actions that we'll talk about will illustrate why there is a desire, I think, on both sides of the V, really, to get some more clarity here. So first, this is a class action, perhaps some of you are familiar with it, definitely got a lot of attention. This is the Dwyer versus Allbirds case, and basically Allbirds was running advertising, like you can see here, where they quantified the carbon footprint of their shoes. So this is not actually a carbon neutral claim. They weren't talking about offsets, but they were telling consumers how much carbon is generated for each pair of shoes, and then there were different numbers for different shoes and so on. So the plaintiff challenged these claims based on the PETA report that came out that criticized Allbirds' methodology. LCA there is short for life cycle assessment, which is a way that companies or academics or anybody will try to quantify the total carbon emissions or other emissions or other outputs or inputs into making a product, and looking at the entire life cycle from cradle to grave and everything that goes in and out. So PETA had criticized Allbirds' methodology, and they also took issue with this data source called the Higg MSI that was used as a proxy for some of the data. It's an industry data source. However, the court granted Allbirds' motion to dismiss, and I think this case sort of goes also a little bit to what Baldo was talking about telling your story, because helpfully for Allbirds, they had a page on their website and then also in other advertising. They basically told consumers, here's how we calculate this. They had the whole LCA methodology out there. They disclosed they were using the Higg MSI. And so ultimately the court found that while perhaps one could quibble with the methodology, Allbirds was being upfront, it was explaining what it was doing, and so reasonable consumers wouldn't expect that Allbirds was doing something different than what it was saying it was doing, and therefore granted the motion to dismiss. So I'm going to talk about two cases now where we don't actually have decisions, but I think these are significant because they show really, I think, a challenge just for everybody right now, which is how do you make a carbon neutral claim? A lot of companies are making these claims. So for example, Danone is making them on Evian. You can see that claim, carbon neutral there. Many advertisers are making claims like this, carbon neutral. There's a lot of certifications out there, companies that will certify carbon neutrality. And the way advertisers usually get there is by purchasing offsets. So I talked about offsets, and just to explain, that's paying usually a third party, although not necessarily, to undergo some activity that will offset your carbon emissions. So again, tree planting is a common one, but there's many different types of initiatives. And then basically, providers of those will sell offsets for a certain amount of money. So if you can figure out how much carbon you're emitting, typically using a life cycle assessment, you could go out and buy offsets to neutralize that and then potentially claim carbon neutral. So this case, though, really seeks to challenge that entire practice because it alleges that consumers would understand carbon neutral to mean carbon free. In other words, that the advertisers, essentially that the advertiser is offsetting their carbon emissions within the process itself, not emitting carbon and then going out and buying offsets. So it's a pretty aggressive theory. It remains to be seen how the court rules on that. As I said, it also remains to be seen whether the FTC will weigh in on the appropriateness of purchasing external offsets to get to carbon neutrality, and if so, what are the guidelines around that? So I think this is an area that's a little bit in flux, but we're very interested to see how this court comes out. And again, like Jed mentioned, in advertising, it's all context dependent. So even if carbon neutral on its own were determined to be problematic here, or even if it just survives the motion to dismiss, perhaps a different claim, for example, carbon neutral with purchases of third-party offsets or something like that would not be misleading because again, consumers would be told what's going on there. So this is the last carbon offset / neutral case we'll talk about. There's some claims here by KLM that look kind of like the general environmental benefit claims Jen was talking about, but they did qualify it, and they explained what we're talking about here is this program where you can go and purchase carbon offsets when you buy your flight, and that would allow you to fly responsibly and create a more sustainable future. However, the plaintiff in this case is challenging the offsets themselves and arguing that there's no credible evidence that they balance out the environmental effects of flying, including because they don't account for other greenhouse gases beyond carbon. So this is another case where the motion to dismiss is under submission, so we'll see how that comes out.
Right, so the next topic is environmental certifications, and I'll say this is a very sexy area for a lot of folks. I mean, it's important for consumers to understand that certain products have been vetted by a third party and that there's been certification. And companies spend a great deal of time and money sourcing these certifications. And so when they're properly obtained, they're very useful for both consumers and companies alike. But even when these certifications are properly obtained, we're seeing lawsuits being fairly filed targeting the certifications and seals because it's a direct target, and it's easy to target these certifications and say, oh well, look, it's not specific enough, or it's not conveying the limited nature of the certification to consumers. So there's a lot of fighting over what these certifications convey to consumers. So again, if we start with the green guides, if you look at section 2606, that talks about seals of approvals. And so we put a quote there that talks about what is permitted, what's not permitted, even if it's been certified by an independent third party. So what does it mean to have a certification, and what does that mean to a business in terms of being challenged in the class action? Well, the first thing that's important is that you could have you could start with a general type certification, and you can make it compliant with the regulations by qualifying it. And so if you are explaining that the certification is particularly limited to a certain sector, I think that's a good way to qualify a claim, as long as it's clear and prominent. So you could do this in many different ways, which we'll talk about. But as long as the basis for the certification is conveyed either through the name or through some qualifying language, you should be in a good position to defend the claim or challenge. So the green guides, like I said, are very useful because they give specific examples. And reading these examples, you get a sense of what's acceptable and what's not. So one example that's given is the broad claim, environmentally approved, or environmental approved. Alone and without context, that's a broad claim. And it's definitely susceptible to a challenge. However, this type of claim could be made to be compliant with the rules if there is qualifying language. And so there, if you look in the last bullet point, first subheading there's an example of the type of qualification that could be used. And those of you that can't see it, it says virtually all products impact the environment. For details on which the attributes were evaluated, go to the website that discusses this product. And so that's a useful statement, or a modification of that statement could be used. A lot of times on these products, real estate is limited, so there's not a lot of room to explain what a certification means. And so you can have a reference to a website, which the consumer really cares about this claim. He or she could go to the website and learn more about it. Let's turn a little bit to some of these claims. So now we're seeing a number of these class actions being filed. One of them that we've seen recently is this case against Walmart. And it has to do with the claim certified sustainable food, and then it has the Marine Stewardship Council seal. And what the plaintiffs here are arguing is that this is deceptive because the methods that are being used are to source the fish sticks or the fish here are not humane, and they cause issues with the environment. So that's a case that we are following. I believe the response is due shortly. But there have been two very similar cases. One filed against Bumblebee, and the other one filed against Conagra, sorry. And in the first one, that case was dismissed without prejudice. We don't know what happened, whether it was a settlement or whether the plaintiffs just walked away, but that was dismissed. And the second case that I mentioned, the Conagra case, that's also being, I believe the response is due next month, so we'll see what happens there. Another example that we've seen is with certain certifications about the Rainforest Alliance. That's a certification that's being used for various cocoa products. And Nestle was also recently sued there. And again, it's in the early stages. A lot of these cases are really still in the early stages, so we'll see what happens after the motions are dismissed, once we get the class certification. But the takeaway is these are targets for the plaintiff's bar, and it's very important that you have the evidence to support it, because when you're in a motion to dismiss situation, you can't present that evidence. But right after the case is filed, you could show the evidence to the plaintiff's lawyers and basically explain to them why this case is not the right case to be brought. And in that regard, I would say a couple of things. As you're doing your diligence to make sure that these seals and certifications are acceptable, it's important to engage with the companies. It's important to engage with the researchers at the company. And so a lot of times when we'll get one of these cases, we'll talk to plaintiff's counsel and we'll say, well, look, you just paid for the certification. And my answer most of the time is, of course, right? The organizations that provide these certifications, they spend a lot of money. They have to hire, right? They have to hire researchers. They have to hire scientists. And they have to do a lot of work to make sure that the certification is proper, that the company's methodologies are proper. And so that costs time, that costs money. And so just because you're paying for a certification does not mean that it's just pay to play. Right? A lot of times there's a lot of science behind this. But as a company, if you're going to engage with these companies and pay them for the certification, you have to really make sure that the scientists are talking. A lot of times it's legal or it's marketing that are talking. I think it's important to get the scientists talking to make sure that what they're certifying or what they're, the benefits that they're saying they're providing are actually scientifically sound.
Turning to recyclable claims, it's a big topic, but we'll get through it pretty quickly. All right, so here's what the Green Guides have to say about recyclable claims. A lot of words on here, but there are a few key takeaways. So first of all, to market something as recyclable, it has to be the case that it can be collected, separated, or otherwise removed from the waste stream through an established recycling program. And the availability of recycling programs and collection sites and how accessible those are to consumers is key. So the Green Guides say that if recycling facilities are available to at least 60% of consumers where the item is sold, then you can make an unqualified recycling claim. If it's less than 60%, your claim needs to be qualified. So there are different ways to do that. One option that the FTC gives is to just say what percentage of consumers have access to a recycling facility. Short of that, the strength of the qualification is just going to depend on how widely accessible recycling facilities are. So the Green Guides give a couple of examples there. Setting aside accessibility of recycling facilities, what happens if part of the product or the package is not recyclable? So if the part that's not recyclable is a minor incidental component, the Green Guides say, go ahead and make that unqualified recyclable claim. So one example is if you have a drink bottle, the Green Guides consider the cap a minor incidental component, and you can make an unqualified recyclable claim, so long as the rest is recyclable. But if the components that are not recyclable are non-incidental, then the claim needs to be qualified to specify which parts are recyclable. And finally, if a product or package is made of a recyclable material, but as a practical matter still can't be recycled, for example, due to the shape, size, whatever it is, it should not be marketed to consumers as recyclable. So we've seen a number of class actions over recyclable claims. So this is a series of class actions that was filed in 2021, alleging that 100% recyclable claims on plastic drink bottles are deceptive because, according to plaintiffs, the bottles are made of a recyclable material, but domestic facilities only have the capacity to process a set amount of those materials, so not all of them will actually eventually be recycled. And also the labels are not recyclable according to plaintiffs, and only some of the caps are recyclable. So motions to dismiss were filed in all three of these cases, and defendants argued that reasonable consumers would not interpret the claim that something is recyclable to mean that it will necessarily, in fact, be recycled into something new. The defendant said, our bottles are made of recyclable materials. In other words, they can be recycled. And whether any given bottle is ultimately repurposed depends on a bunch of things that are beyond our control, including just the capacity of the recycling facilities, how much of similar materials they're collecting from other sources, and the demand for those materials. So just to give you the spoiler up front, all three courts agreed with the defendants in these cases, and all three cases were dismissed. So let's take a look at them. All right, so in the Duki-Maza case that was filed against Niagara Bottling, the court granted the motion for failure to state a claim. So Baldo mentioned the Green Guides act as a safe harbor under certain consumer protection statutes. That includes New York, and that's where this case was brought. New York's consumer protection statute says that it's a complete defense to liability if an act or practice complies with FTC rights, which includes the Green Guides. So here the court noted that the Green Guides focus on availability of recycling facilities and not the actual incidence of recycling. So the fact that not all of the bottles are actually recycled, even though they are recyclable, fails to state a claim. All right, second, the court said, even though some of the caps and the labels are made with non-recyclable materials, these are minor incidental components of the bottles under the Green Guides, and of course, as we just saw, the Green Guides say if you have minor incidental components, you can still make that unqualified claim. All right, moving on to Swartz. Same result, court said no reasonable consumer is going to understand this claim to mean that the entire product will necessarily be recycled. It's about recyclability, not what actually eventually ends up being recycled. And again, looked to the Green Guides and said the plaintiff's interpretation here of the claim was inconsistent with the Green Guides. An amended complaint has been filed in this case, and the motion on the amended complaint is currently pending. All right, Haggerty. So this one's a little different. This one was filed in the District of New Jersey, and here the court dismissed it on lack of standing rather than failure to state a claim. So first, as to the claim for monetary damages, the court rejected the price premium theory and basically said it was too conclusory. Plaintiff didn't actually allege any facts regarding comparable or cheaper products to show that plaintiff paid a premium price here. Just said, I wouldn't have bought this, I wouldn't have paid this premium price had it not been for the recyclable claim. And then as to injunctive relief, we see this a lot, but the court said the plaintiff's allegation that she was likely to suffer future injury was too speculative. She alleged that she wanted to purchase the products again in the future, but whether she does is just pure speculation, entirely up to her. And even if she would purchase them again in the future, if they were properly labeled, those allegations lack the necessary imminency and don't result in a substantial risk of harm sufficient to generate injury sufficient for injunctive relief. All right, this is a slightly different case concerning a recyclable claim. So here plaintiff alleged that 7-Eleven's store brand plastic products were falsely labeled as recyclable for two reasons. First of all, plaintiff said they don't have the resin identification code that you see at the bottom of packages that basically allow products to be separated at the recycling facility. And second, the plaintiff said most recycling facilities actually don't even recycle the types of plastics that are being used in these products. So 7-Eleven filed a motion to dismiss, made the same argument that we saw previously on the second theory. Basically, recyclable doesn't mean that the product will actually be recycled. It just means that it is capable of being recycled. So the court had a split decision here. On the second theory, the part about certain of the plastics were not actually commonly recycled at facilities, the court said plaintiff failed to state a claim. 7-Eleven didn't make any claim here about the availability of recycling facilities, and the fact that they were limited didn't mean that the products are not recyclable, basically consistent with the water bottle decisions that we just saw. So you might be wondering, how does this fit in with the Green Guides and what the Green Guides say about availability of recycling facilities? So as we mentioned, compliance with the Green Guides do provide a safe harbor in some states, not all states. But the flip side of that is restrictions imposed by the Green Guides are not necessarily binding on courts. And the court here basically said, it noted that the complaint relied on the Green Guides, but said it is not clear how useful those Green Guides are when evaluating the views of a reasonable consumer at a convenience store. The average consumer at 7-Eleven probably doesn't have the Green Guides on hand when they are picking up their phone plates. And people buying red party cups at 7-Eleven are more likely to be thinking about beer pong than the FTC's consumer guidelines. So that claim went away. On the resin identification code, the court said that part was within 7-Eleven's control. 7-Eleven could have put on those resin identification codes, and plaintiffs alleged that the products need them for the products to be recyclable. So the claim was sufficient to survive a motion to dismiss. Another slightly different series of recyclable cases. So these are cases filed against makers of recycling bags. So those are those clear drawstring bags that you see people sometimes use to put out their bottles and cans. So plaintiffs allege that the packages and labels for these bags misled consumers into thinking that not only can they be used for direct recycling, but that the bags themselves are recyclable, when they are actually made of a plastic that is not recyclable and allegedly contaminates the waste stream. Pretty much all of these cases appear to have settled or have been voluntarily dismissed at least. But before the Hanscom case settled, the one against Reynolds, the court did decide the motion to dismiss and rejected Reynolds' argument that consumers would not think that the bags themselves are recyclable just because they're advertised as recycling bags. The court said a reasonable consumer might understand the term recycling on these packages to mean that the bag is either capable of being recycled, or at least that there's something about it that is more suitable for use in the recycling process, and might not expect the bag to actually contaminate the waste stream, impede the recycling process. The explosion in environmental cases has been a little more recent. This is a slightly older case, just within the framework of that recent explosion. The 2018 is not that long ago. So here plaintiff alleged that K-cups were not recyclable because even though they're made of recyclable material, they are too small to be recycled in many communities and are also often contaminated with food or paper filters, so that the facilities can't actually recycle them. So the court denied the motion to dismiss in this case and actually granted class cert. The case subsequently settled for $10 million. Cure agreed to modify its advertising to add sort of qualifiers that we've been talking about to make clearer the extent to which it can or can't be recycled.
Yes. So we're going to move to biodegradable and compostable claims. And so you see these often with product packaging, or sometimes with certain more biodegradable but liquid products. And the idea here is that advertisers sometimes want consumers to understand that when they dispose of the product, they can do so either in the normal waste stream and the product will break down, or potentially even at home. And the FTC does have guidance here in the Green Guides. So with respect to compostable claims, again, you need competent and reliable scientific evidence. You have to show that all materials of the product are compostable, or jumping to the last bullet, you could qualify it if that's not the case. And then you have to show that the materials break down in a similar period to that of the underlying materials in a safe and timely manner, including that if it's meant for home, that has to be able to break down in someone's backyard or in their home, or if it's meant to go into the waste stream, that there's a substantial majority of communities where people can actually get that at their facilities. And then the time should be similar to that of the underlying material. Biodegradable claims are similar, a little bit different. You have to show that the materials will all break down completely to elements found in nature in less than 1 year, and they have to degrade under the conditions in which the product is customarily disposed. There's a whole host of different types of biodegradable claims we won't go into, but these requirements apply to them all. And I think, again, the key is if there are any limitations on how your product breaks down, again, maybe the entire product isn't biodegradable, or perhaps it takes longer than a year, that's something that can be addressed through disclosures. So like the other claims we've talked about, this has drawn some attention from the plaintiff's bar. And so this is a case where the company was marketing these single-use plastic products as compostable. However, the plaintiff alleges that the products are not entirely compostable because they contain PFAS, and that's a whole other trend right now in class actions that we won't get into beyond this case, but basically the plaintiff alleges this is not compostable because there's PFAS which don't break down. The defendant, though, pointed to a California law, and it doesn't go into effect until 2026, but that California law limits or will limit compostable claims to products with no more than 100 ppm PFAS, while the complaint, or the plaintiff here, was seeking to impose a essentially zero PFAS standard. Any PFAS would mean it's not compostable, and so the defendant is arguing that that contradicts the forthcoming California law. I think there's a little fight over, well, what about the fact that it's not in effect yet? But I think, California has signaled its intent here, so I think the defendant has a good argument that there shouldn't be a zero PFAS threshold. That motion to dismiss is pending, so we will see how that comes out. There have been a few cases involving pet waste bags marketed as compostable. It's a little hard to see, but in that purple box, that's where the claim is. I think it says certified compostable. The allegations in these cases, in this case, is that while the bags might be compostable, they're not compostable under normal conditions at home or because of the pet waste. And then if you send them to industrial composting facilities, they're not suited to handle these types of products with pet waste in them. So basically you'd have to seek out a facility or mail this to a facility. I don't know if anyone's actually doing that. I hope not. But anyway, the point is it's not easy for consumers who want to compost their dog waste in these bags to go out and do that. The defendant pointed to disclaimers. I don't see any on the front of the package. They might have been on the side. I think there might have been on their website and so on. And basically argued, we tell consumers not to do home composting with this, and then to check with their local facilities before sending in their pet waste in the bags, and argued that we've complied with the green guides and so on. So that motion to dismiss is also pending. It's been pending for quite a while, I think, but we'll have to see how that one plays out. And there have been a few more cases in this area. The first case is similar to the one we just talked about. It's another pet waste compostable case. The next one, Yarmark, is another biodegradable case involving single-use cutlery. Instead of PFAS, the allegation is that there's polyethylene there. So there's all sorts of chemicals that the plaintiff's bar might try to point to in these cases and argue that the product's not biodegradable. And then the last case, the water wipes case, they were claiming, this is a pretty recent case, 100% biodegradable, and the allegation is that the products don't completely decompose within a reasonable period of time when people throw them in the trash. All of these cases resulted in a voluntary dismissal. So again, we don't know what happened there. It's possible there was an individual settlement. It's possible the plaintiff walked away. Maybe they were presented evidence that persuaded them to walk away. So you never really know, but definitely there are a lot of cases involving these types of claims.
All right, non-toxic claims. So the green guides do provide some guidance on non-toxic claims. It's pretty limited. They basically say, standard guidance, claim needs to be supported with competent and reliable scientific evidence, not super enlightening. But beyond that, the FTC says to qualify non-toxic claims to the extent necessary to avoid deception, of course, and that non-toxic claims likely convey the message that the product is non-toxic both for humans and the environment. There has been some litigation over this. So last year we saw a class action filed against Venus Labs challenging claims made on a variety of Ecos branded household products. So the plaintiff alleged that claims here like non-toxic, safer, climate positive, earth friendly, so on and so forth were false because the products allegedly contain certain harmful ingredients. There's a motion to dismiss pending in this case. Venus Labs has basically argued plaintiff failed to allege sufficient facts about the makeup of the products or any evidence that the products cause harm in the real world, and in any event, the ingredients are clearly and conspicuously disclosed on the label. So we'll see how that plays out.
Okay, so our last topic is reef safe or reef friendly claims. So these don't actually appear in the green guides, but there have been a number of cases, and they've gone pretty poorly for the marketers. Just run through these quickly. And these generally, as you might expect, involve sunscreen products, right? That's typically where companies are marketing the products as reef safe. The concern being from consumers that the sunscreen might leach into the water and damage coral or fish or things like that. And so in this case, the plaintiff alleged that the reef safe label was misleading because of certain ingredients that allegedly endanger the reef. And they pointed to various scientific studies on the alleged harmful effects of these chemicals and pointed to some government bans on these chemicals. So the marketer here moved to dismiss and basically argued that while we do advertise the product as reef safe, we disclose on the label that means it does not contain oxybenzone or octinoxate, and those are two different chemicals not listed at the top there, but those chemicals are banned in Hawaii. So they basically said, we're telling consumers that we're reef safe because we don't have these two chemicals. The plaintiff argued, well, there's these other chemicals that are still harmful. And the court denied the motion to dismiss, and basically, there's some of the language is here, but essentially was saying to Strivectin, you can't redefine reef safe or reef friendly in a way that consumers might not expect, and certainly not with a disclosure on the back label. Consumers may not expect that sort of limitation on the claim if it's not prominent enough. After the denial of the motion to dismiss, the party stipulated to dismissal. Again, you could draw an inference from that. The Kroger case, Kroger took a bit of a different direction. They argued that reef friendly, again similar to reef safe, is puffery. In other words, that it's not actionable, that consumers would not expect substantiation. And they pointed to other cases involving friendly terms that have been found puffery, so like user friendly, in a very different context, have been found to be puffery. So here, even though the green guides don't address reef friendly claims, the court pointed to the green guides in other friendly claims that appear. They're really general environmental benefit claims like eco-friendly, environmentally friendly, but the court said the FTC requires substantiation for those types of friendly claims, and so I don't think it's puffery, at least at the motion to dismiss stage, to call a product reef friendly. Kroger also argued that the case should be dismissed or stayed under the primary jurisdiction doctrine, which is basically a doctrine that allows courts to defer to an agency like the FDA or potentially the FTC or others. And Kroger argued that there's pending legislation in Congress that would direct the FDA to develop regulations for a reef safe designation. However, the court thought pending legislation then to potential regulations coming from that was just too attenuated and remote to invoke the primary jurisdiction doctrine. So that did not warrant dismissing or staying the case. The last case involved Supergoop. So same type of claim, reef safe, and you can see there were other environmental benefit claims as well, safe for you and the planet, and so on. The plaintiff pointed to some of the same types of chemicals and alleged that they're toxic to human health, coral reefs, and marine species. And they pointed to an article from the Center for Biological Diversity to support the allegation. And they also pointed to legislation that had passed or was pending in certain states and other places that was banning these chemicals as a concern for reefs. So the defendant took a different approach here. You can see, I think defendants were sort of searching for different theories in these cases. But again, was not successful. So they argued that the complaint failed to satisfy Rule 9b. Since the complaint standard in fraud, the complaint was held to that higher standard. And they argued that the support for the allegation of falsity lacked the requisite specificity under 9b. However, the court disagreed and found that the plaintiff alleged that who, what, when, where, and how of all the purported conduct, and found that there was enough specifics in terms of alleging the falsity, pointing to the pending legislation in Hawaii, seeking to ban the ingredients, bans that existed in other locations, and then that article I mentioned. The defendant also argued that this was really a veiled lack of substantiation claim. In other words, a claim that alleges the defendant does not have substantiation for its marketing claim. Courts, including the Ninth Circuit, have said that plaintiffs cannot proceed on a lack of substantiation theory. They have to come into court and plausibly allege falsity to get through the motion to dismiss phase. And so, often defendants make that argument. We've succeeded in making that in a lot of cases, but here the court basically said again, they pointed to specific facts that supported an inference of falsity, not just lack of substantiation, and so the claim survived. So we left a little bit of time for questions. I don't know if there's any in the audience.
David, back here.
Hi, I was wondering if you had seen any uptake in cases being filed under 23B2 for injunctive relief as a way of avoiding some of these damage questions that some of these cases go away.
I don't know if you guys have, but we've seen cases being filed outside of the class action context. So what we've done, we've seen cases being filed on an individual basis just for injunctive relief to avoid, for example, federal court. So I've seen that.
Yeah, I think in terms of, right, so I think that's a new strategy. We'll see how that shakes out to try to avoid federal court. I think in terms of federal class actions, I think usually you more so see the flip side where there's damages and not injunctive relief side, usually, or sometimes the side gets dismissed, usually just because of an issue with standing. And I think, Jen, there was a case you talked about where that came up. But we see that in a lot of cases, and basically the gist of the argument, and it is usually pretty successful, is that once a consumer understands the alleged deception, they lack standing to seek injunctive relief to cure that if they're not at risk of being deceived again. And so I think these days we more so see cases for damages without injunctive relief, but it is an interesting potential trend that case Baldo's talking about. So we'll see if that takes hold.
Yeah, and I think also with the Ninth Circuit decision in Sonner, the impact that's having on equitable relief. And a lot of these cases are filed in California, and the ability to seek equitable relief in California, it's going to be interesting to see how that plays out.
So we just compiled a couple of questions that we've gotten when we've done these presentations, either at clients or at other events. So we might as well just share those. So one question that's come up a lot, Jen, maybe you could handle this, is how often do these cases get certified?
Yeah, so we're only aware of the one, at least the K-Cup case that we talked about earlier. And you could sort of attribute that to a couple of different things. One is, again, this is a relatively new area where we're recently seeing an explosion of cases. So a lot of these cases maybe just haven't gotten to class cert yet. As we mentioned, a lot of them are voluntarily dismissed early on, so they never quite get there. And I think there's going to be some interesting questions if and when they do get there as to the ability to certify. It's probably going to vary from case to case depending on the claim and the prominence of the claim, so on and so forth. But the ability to certify these cases on claims that don't necessarily go to what the core of the product does, but rather let's call it an ancillary benefit, and the extent to which we can show that consumers are uniformly, or at least the majority of them, are relying on these claims, or even notice them when they were making purchase decisions.
So another question we often get, we sort of focus more on the merits, but is what do settlements look like in these cases? And Baldo, you want to take that?
Sure. So with settlements, obviously, there's the public settlements, the class action settlements, and we get a sense of what they're like just by the sheer number of cases that are filed and the number that settle on a case-wide basis. You can tell that the case-wide settlements or the class settlements are an outlier. And so most of these cases get voluntarily dismissed. And again, there's, you can infer from that that maybe there's an individual settlement, or perhaps the plaintiffs just walked away based on the evidence shown. But if you look at the class-wide settlements, there haven't been many. The Cura cases is one of them. That's the case that from 2018, so it's been a while. It's been around for a while, and there was a $10 million class fund. That was the monetary relief, and then there was also modifications to the labels, advertising, and marketing. And it said something along the lines of like, checked locally, not recycled in any communities. Because obviously that was the issue of the case. It was that, yes, they are recyclable, but not in a lot of communities. So that was the injunctive relief. It was to clarify that. Again, sustainability, especially with salmon and other type of fish products. We've seen one case. It's the Maui case, where that was the claim was that the claim at issue was sustainably sourced, and plaintiffs argued that industrial farms don't use sustainable and friendly and environmentally friendly practices. And there we saw a very modest settlement, I would say, for a class of 1.3 million. And the huge outlier in all of this, right, is the multi-district litigation involving Volkswagen. And I almost don't want to put it in this bucket. It's a completely separate bucket, but that was a $10 billion settlement that had to do with claims such as clean diesel, green, environmentally friendly. And so that was one where there was a $10 million pool fund. Billion, sorry, yes. And then there was, in addition to that, some buybacks of vehicles. There was also provisions to allow leases to terminate. So I would say that is really an outlier, even in the class settlement outliers. So the last thing I do want to end this on is maybe get some thoughts on what we see the green guides, what the revisions to the green guides could look like. What is the FTC looking at, just from comments that you've seen?
Yeah, so the FTC, the deadline for comments was a week or two ago. They received hundreds from industry, thousands from consumers and other groups. So I haven't reviewed them all, but I think just sort of reading like coverage of it, I think the trends that I would say people hope or expect the FTC will cover. So one is sustainable, which is not explicitly covered. You can argue that's a general environmental benefit claim, but there's a lot of desire, I think, to have the FTC weigh in on that term. They declined to do that in 2012, so we'll see if they do that this time. But again, that's a claim that has continued to be used and has led to class actions. Aspirational claims, so like for example, the code case that Jen talked about, you often see on companies' websites, a page about what they're aspiring to do in terms of getting to carbon neutrality or being more environmentally friendly or whatever. And so there's a question of when do aspirational claims require substantiation, and what should that substantiation look like? And I think that has been a challenge for marketers, for courts, and so on. And so I think there's been a lot of requests to the FTC to weigh in on aspirational claims. Another area, so I talked about carbon offsets and carbon neutral claims. The green guides do address carbon offsets, but they don't, so that's one side of the ledger, right? Purchasing the offsets to drive down, if you offset it, your carbon emissions, but the other side of the ledger is how much carbon you're emitting, and you have to calculate that. And then there's also the question that as raised by some of these cases of whether it's even appropriate to make a carbon neutral claim or something like that, where you're relying on third-party offsets to do that, rather than offsetting it within your manufacturing chain itself. And so that's another area where there have been a lot of requests to the FTC to weigh in. And then another area where there has been a ton of demand, and actually the FTC is holding a workshop on May 23rd, and you can go in person, or I think there's a Zoom link or something like that we're planning to watch. And this is on recyclable claims, because this is an area where obviously the green guides have a lot of guidance as is about how to make recyclable claims. They get very specific, but I think the challenge these days is that just the way the world works and the country works is that a lot of materials are recyclable, but they don't get recycled. And so, courts have generally been receptive to the argument by defendants that if we're saying something is recyclable, and that's true, it shouldn't be our responsibility, and we shouldn't be accused of false advertising just because a local facility decides not to accept it for some reason. But that's an area that I think there's been a lot of demand for the FTC to provide guidance on. What happens when something, just for whatever reason, it doesn't actually get recycled. And so we'll see if they weigh in on that. I think the workshop will be informative, both for us and probably for the FTC in terms of what people think needs to be done here. So I think those are some of the main areas. We're definitely, I think, excited to see what comes out of it, because we find the green guides really useful in counseling clients, and they allow us to give clients guidance that hopefully means that they'll never get one of these class actions in the first place. So we find them to be a really useful tool, and hope the FTC will do a good job, and expect they'll do a good job in updating it.
All right, well, thank you all. Appreciate it.